Good morning to all. My name is Gustavo Bonet, and I've been designated as hearing officer to preside over the technical hearings being held in relation to the petition for rate review filed by the Puerto Rico Electric Power Authority, docket number CEPR AP 2015-0001. We begin this pre-hearing conference on November 28, 2016 at 10:18 a.m. As previously notified through resolution dated August 15, 2016, the Commission will hold a technical hearing. The technical hearing is scheduled to begin Tuesday, November 29, 2016 at 9 a.m. and is scheduled to continue until Friday, December the 16th of 2016. The purpose of the technical hearing is for PREPA and interveners to participate in a questions and answer session with regards to each party's pre-filed testimony. The purpose of this pre-hearing is for the Commission to address any procedural questions and/or objections raised by PREPA or the interveners, and to clarify any questions with regards to the procedures established by the Commission for the technical hearing. The Commission has gone to great lengths to establish a schedule which provides for the adequate discussion of all topics deemed by the Commission as relevant to the issue at hand, and which are central to the Commission's ability to set just and reasonable rates. All procedural objections or questions must be addressed during this pre-hearing conference. The Commission will not address any objection made during the technical hearing which could have been made during this pre-hearing. Pursuant to the Commission's November 22, 2016 resolution, the technical hearing is organized into 9 panels, each panel addressing a specific topic or issue, and each composed of 1 or more witnesses as selected by the Commission. That information has already been shared, and I believe that there have been documents provided to all present regarding that area. Each of these first 8 panels will be composed of witnesses for PREPA and interveners, as well as by those Commission experts who are counseling the Commission on the subjects discussed during each panel, if any. Panel 9 will be comprised of the attorneys for PREPA and interveners. For panels 1 through 8, the Commission staff will question PREPA and intervener witnesses. Once the Commission has concluded its line of questioning, PREPA will have an opportunity to question intervener witnesses. Finally, interveners will have an opportunity to question PREPA's witnesses. The Commission may provide PREPA or interveners an opportunity to ask redirect questions to their witnesses. However, such opportunity will be subject to time availability, and it is not guaranteed. Finally, Panel 9 will consist of questions only from the Commission to the party's legal representatives regarding specific legal issues which the Commission must address in its final resolution and order. Later on, the Commission will share the list of issues before the legal panel. The schedule developed by the Commission and notified in the November 22nd resolution includes the latest possible time at which a panel may start. That is, the time identified on the Exhibit A on the November 22nd resolution consists of the start date for each panel if the entire time allocated to each panel is consumed. The Commission will, however, seek to manage time as efficiently as possible. As such, any panel may commence at an earlier time. Witnesses and parties participating on each panel must be present at the Commission's hearing room during the panel immediately before, so as to ensure they are present if the panel in which they are to participate begins prior to the scheduled time. The Commission may assess administrative sanctions or fines on any party who fails to be present during any panel for which he or she has been called, unless such witness or attorney, in case of Panel 9, has been excused by the Commission previously. When asking questions, a party's questioner may not repeat questions which have already been asked. Parties should listen carefully to the Commission's questions to ensure that their questions are not repetitive of questions already asked by the Commission. When asking a question, the questioner must indicate to whom the question is made. If referencing a document, the questioner must identify the page and/or line of the document prior to asking the question, in order to provide the witness sufficient time to find the reference. If possible, before beginning a line of questioning, the questioner should identify all documents to which he or she shall make reference. Witnesses must refrain from repeating answers previously given, and their responses must be succinct, but sufficient to adequately answer each question. Only the witness to whom a question is asked may answer the question, unless the party asking the question allows another witness to answer. For purposes of the technical hearing, witnesses are to be deemed to have been asked all questions stated in their pre-filed testimony and to have provided the answers stated therein. All pre-filed testimony and supporting documents, as well as the petition and information provided pursuant to any request for discovery, are deemed to have been admitted to the record, unless stated otherwise by the Commission through a resolution or order. Witnesses are not required to be introduced by their attorneys. Each panel will be sworn in, and each member of a panel will be asked to identify themselves. The Commission will ask those PREPA witnesses who filed rebuttal testimony to adopt such testimonies under oath. All parties are hereby warned that they are responsible for bringing all relevant documents and copies for all other parties present. The Commission will not provide copies of documents which have been filed before the Commission. The Commission will reference such documents when asking questions, and all parties are responsible for having such documents at hand. Now, are there any questions with regards to the procedure established herein? Yes? Please introduce yourself when you address.
Morning.
You could press that button. Yes.
Good morning. My name is John Ratnaswamy. I'm one of the outside attorneys for PREPA. We noticed one of the intervener witnesses does not seem to be listed on any of the panels. And that is Mr. Nelson Ramirez, who is for CUD. And we just wanted to point that out in case he was mistakenly left off.
Okay, and that will be, he will be a witness for which party?
CUD, I forget their full name.
All right. We'll take that into note, and we'll make the necessary arrangements. If there's any information that we need to provide to all here, we will do so either through an email during the day today or early in the morning before we start at 9 a.m. sharp. So all parties will have the information regarding it.
And then I have, if I could, a second question about something you said. Did you say, Your Honor, that all of the discovery responses will be treated as part of the evidence without sort of automatically? Is that, I think you said that, but I wasn't sure.
Yeah, what I said was all pre-filed testimony and supporting documents, as well as the petition and information provided pursuant to any request for discovery are deemed to have been admitted to the record unless stated otherwise. So we're going on the premise that it will be admitted. However, since we know that in the development of the hearing, there are issues that might arise, we're giving leeway for the Commission to address those either by resolution or through a ruling.
So if I could just, for example, if, say, we asked a witness about a discovery question about their experience, and they said, here's my experience, and they did that in the discovery, that unless the Commission says otherwise, that's already part of the evidentiary record.
However, what we're trying to get at is if you make a direct reference, for example, in which part of the discovery that was part of it, then it will better serve the Commission by helping us have a direct reference to how would that be part of it. If that reference is not there, then it could provide for the Commission to deem it not pertinent or maybe not, an issue outside the record, and then it might not be.
All right. Thank you.
You're welcome. Any other party or intervener has any question in regard to the procedure? Yes, could you?
Can I just stand up and state my name? Because it's a little bit clumsy for each one of us to go just for one question and then come back.
Well, yeah, just make it loudly, I guess, so we can.
What is?
Could you state your name? Okay.
I'm not gonna for it's, what is the consequence of not having a witness present at the hearing? Does that mean that his testimony is removed from the record?
Yes.
The next question is, why the expert witnesses, the appearing witnesses, are not fact witnesses in many cases. They are interpreting the facts that were provided by the PREPA and the Commission. So whether he actually has knowledge of specific facts, like if it were in a tort case in court, doesn't sustain that determination.
Well, as of now, the determination is that such information will be deemed to be out of the record. The commission is trying to examine all the information brought forth to it. Thus, if a witness is not here to be able to be cross-examined by the other parties, then it leaves all the other parties at a disadvantageous position onto that information that's being brought by that party.
But if we're
Witness.
talking about unadvantageous situation, the position that the commission is putting the interveners, it's the epitome of unbalanced procedure. We don't have $20 million in outside resources to support our expert witnesses. We are individual units that have some capacity to be here and to present what we understand, correctly or not, it's the public interest. But we don't have the capacity to increase the rates if I have to put $10 million more in.
Well, if you have an argument to make on that point, I suggest you file it by motion, and then, well, it will be resolved at its due moment. If that's referring to a previously filed motion, all those motions will be dealt with either today through a resolution by the commission or here. We haven't gotten still through the agenda of the hearing, so maybe your issue is an issue that will be later on. This was more in regards to the procedure that I had just stated at the beginning of this hearing. Thank you. Any other questions? All right. Great, so we'll move to the pre-hearing agenda. As previously stated, and as it also provides by the resolution on panels promulgated by this commission on November 18th, all panels are already scheduled. We're gonna make note of what Mr. John Ratsawani, sorry if I mistakenly misspoke your last name, noted regarding Nelson Ramirez. We'll make note of that, and anything in regards to such, the people that are gonna be part of the panels will be informed if any changes should arise. The instructions on panel start time, we want everybody to be able to be here at least 10 minutes before. We recommend 15 to 20 before, because we want to start at 9 a.m. sharp. We don't have a lot of time allotted. There's a lot of information. We are all aware of it. So it's gonna be the commission's, it has been, its practice to begin sharp at 9. Now on to the order of participation during the technical hearing. As directed by the commission, the hearings will be conducted in this order. The commission and its experts will ask questions first. PREPA would be the second questioner. Interveners will be third. PREPA will be allowed a redirect subject to the availability of time. All parties are being made aware at this point, and will be also in the future, that no repetition of questions regarding issues or subjects will be allowed, dealing with either subjects or issues that have already been addressed by the commission, PREPA or another intervener during their questioning. We need to remind everyone that there might not be enough time for everybody to ask the questions they want. Thus, if a party is not in the room, when the commission's lawyers were asking questions, a party may be in danger of becoming repetitious and therefore losing their turn. There will be no repeat questions asked by commission just because any of the parties did not like the answer. Also, this applies to all those parties who might not bring an attorney to provide for the questioning and might be making questions. All rules apply for attorneys or all other parties making questions. There'll be no arguments with witnesses, and there will be no drawn-out setup for questions allowed. Please reference the evidence on the record that's gonna be part of the question, and also reference any information, be it from discovery or from exhibit names, that will be pertinent to the question being asked and the answer being given. Witness availability will be only excusable unavailability due to emergencies or unforeseen issues. In such case, as there are any excusable emergency or unforeseen issue, the parties need to notify all other parties and the commission immediately so that the commission can decide on the procedure that will be done in terms of having to reschedule certain panel appearances and the like, which again, I wanna notify to everyone that that will be the exception to the rule. For admitting evidence into administrative record during the hearing, as I previously stated, the basis will be that everything that was part of the discovery, as well as what was filed by PREPA and the petition information provided pursuant to any request, is deemed to have been admitted to record. However, we know that there might be, in the fluidity of the procedures, there'll be information that might be come up. At that point, then the party that wishes to have any evidence brought forth needs to make a reference to it and be able to relate it to the information that's already in the record for pertinency. We're really not gonna be bringing information that could be outside of the record, might not have any value to aid the commission in making their determination. Also, as previously noted, we're going to allow PREPA witnesses to adopt under oath their rebuttal testimony during their testimony before the commission. In that way, we'll make sure that the information that's provided to the commission is complete and that all the information that was brought as answers by PREPA can be part of the record. Now, on the expert reports being made public by the commission, the reports of the experts of the commission was made public in light of the importance of this case and to bring everybody the information that will help the commission get their decision made. Thus, that information, we hope, that helps interveners see another light into what has been brought by PREPA. It's an issue of transparency and bringing forth everybody in terms of the information that we have. However, we want to make clear that the commission will not provide for discovery of such reports due to the fact that those reports are based solely on all the information already provided by PREPA. In that light, then if any of this reference, I know some of you have already gone through the expert testimony and have noticed how it references directly to any and all information that was part of the record. In that way, then that would be addressed. Yes, sir?
Once you're complete, I had a comment from PREPA's standpoint.
Okay. Well, what's your name? And
I'm sorry, Michael Guerra,
okay.
outside counsel for PREPA.
Yeah.
I would like to raise a point with respect to the expert reports once you're
Go ahead.
through your comments.
Go ahead.
So it's my understanding from what you just said that the reports would be admitted to evidence for evaluative purposes. So evaluative, what I mean by that is that they evaluate what what PREPA and interveners have presented and present a report to the commission based on what has been presented. On the other hand, I'm assuming, or what I'm hearing, is that the reports are not being presented as additional evidence for new proposals or things that, for example, are not in the, not related to evaluating the evidence.
Correct.
Okay. So to the degree that the reports are evaluating, well, let me back up. First of all, we appreciate the transparency. I think the reports are very helpful to us, and PREPA appreciates it. To the degree, as we've gone through the reports, and we've only had them for a couple days, to the extent that they do raise some new positions, then we would raise that. It would be problematic for us to the extent we would not have a chance to respond to that new position. And ultimately, if there's an assumption that that position is based on that is not in the record or is a mistaken assumption, it could ultimately lead to a bad order. So that's where it is problematic for us, but maintaining that if they are evaluative, we have no objection.
Well, we want to make clear, commission experts will participate on the hearing panels. So you'll have the ability to bring forward, and it will be on all the same subjects that the rate case will be looked at as a whole, and specifically to the matters that they discussed in there. So if that is the worry, I think that it will be covered. Remember that also the commission has to go through the process of listening to every day of the evidence that's going to be bring forth, and not only by parties, but by PREPA, and has had time to analyze the evidence previous to, outside of what the experts might say, and it's not subject to what any expert might say in any of those reports. So I think that also there has to be a sense that there will be an opportunity greatly for maybe PREPA to move the discretion of the commission.
So what I'm understanding is we would obviously have cross-examination. We would cross-examine the experts. But let me ask an additional question. If there is a position, and I can give you an example where there is something new that is based on assumptions that we would like to respond to, would PREPA be given the ability to bring some redirect testimony of a witness to respond? And I can give you an example if you'd like.
Go ahead.
In one of the experts' reports, they talked about billing interval data, and we would want to respond and talk about the feasibility of that and what systems would be needed, what investment would be needed. Without addressing that, the record wouldn't have it. We would try in cross-examination to bring that out, but we would ask for at least redirect so that, or PREPA would have the ability to bring evidence to rebut that.
Well, I think, and this is just going on your example, so I don't want to give, my perception of how things previously can happen without they coming up on the actual hearing. But having those, I believe that having the reports from beforehand, it helps you prepare your PREPA witnesses so that in the fluidity of you bringing that evidence forth, whichever evidence you deem necessary, then you'll bring forth evidence that could then be looked in the light of that expert report as in rebutting it.
Okay.
Just by the function of what questions you ask and what comes from. I mean, we're really about trying to get as much information as we can to clarify the information that was provided by PREPA and the positions of all the interveners. So I believe that you can look at it as we're going to be more open to receiving more information than being limitative of any opportunity.
Okay, that works. So what we will do, though, is if appoint additional questioning pertains to a position in the reports, we will point that out to you and
Yeah,
say that
that would
this,
be great
so that
also.
you'll know that it's part of our response to what we perceive as a new position or something that is beyond evaluating what's in the record, something new.
Yeah, not only that, I mean, I think it will help the parties, reference to it and learn why is it that is and be analyzed. Thank you. Yeah, now we're gonna go over some of the motions that are still yet to be resolved by the commission on issues that will be maybe modifying the way we do things in the hearing. First of all, I wanna be able to notify that the commission will express their position on the motion for reconsideration on rejecting rebuttal filed by PREPA. That should be notified probably today. I don't want to say more because it's beyond the scope of my duties here. We're going to move on to Ixes Perez's motion regarding witness availability. If you could come forth, or would you rather stay in? Okay, great. So this motion filed by Ixes Perez on the 23rd of November 2016, presenting alternatives to comply with the Commission's technical hearing schedule. I believe the first issue had to do with the availability of Dr. Tom Sancillo and Kathy Kunkel. We informed that they can come individually, one or the other, at your decision. Just make sure that they can address all issues. And if you could please notify that today by email to all parties, the commission, of which person will be the person that will be, if it's gonna be Dr. Tom Sancillo or Kathy Kunkel, who's gonna be present. Yeah. Also inform which day so that we can be able to address it on the panel. Thank you so much. Also, on the second issue, dealing with Dr. Victor Glass, and how they will be able to appear before the commission. The decision is to have Ixes Perez and PREPA be able to converse on the issue. If PREPA decides that they want to be able to do any cross on Dr. Glass, then for you guys to decide then which day and when, so that you can move the schedules. If not, then please let us know, so that then if we decide to make any accommodations further, meaning addressing the issue that you brought forth in terms of maybe not availability, but maybe not that type of cross, then maybe then it could make the record and there will be no problem. Thank you. Now, in regards to Ixepe's motion regarding re-rebuttal, the commission had provided a procedural calendar that I think it clearly stated that there will be no availability of re-rebuttal. So the determination by the commission at this point is to not admit the re-rebuttal. Now, on to Aconairs and Home Builders' request to waive requirement of use of attorney to conduct interrogatory. Excuse me, yes?
What is the legal basis to permit PREPA to have rebuttals, but not the interveners to have rebuttals? We're just parties to the same proceeding. Just want
Excuse
to
me.
know the legal basis, so to see if I have.
Could you come so that we can keep the record?
Fernando Agaray, for Vista.
Could you press the button?
Oh.
Yes,
I,
you can, it's already on, thank you.
okay, I'm asking whether there is a legal basis for the distinction of PREPA being able to file rebuttals, but the interveners not being able to file rebuttals, because after all, we are parties to the same proceeding, and we are covered by the same rights.
You'll have rebuttal, you won't have re-rebuttal. So you won't have a second turn. You will have a turn of rebuttal. You will just won't have a turn after that one to complete, and that's completely at the discretion also of the commission on the re-rebuttal. It's gonna let you have your rebuttal time. You just, once that's over, you won't have another chance after that one.
When is the rebuttal time? The hearing?
In the hearing, after the testimony has been given by the witness of the other party,
Oh.
and per panel.
Now I understand, okay, fine.
Now back to Aconair and the home builders, request to waive requirement of use of attorney to conduct interrogatory. The commission has decided to provide for that to happen. However, we want to make clear that all same rules that apply to any other council present will be applied to home builders and Aconair. So in terms of the questions, the pertinency, sticking to the rules of conduct for any council here, it's gonna be enforced. And thusly, if there's any issue regarding pertinency or questions that are outside the scope, then you could be limited the type of questions that you'll be able to have and the time, just so you're all aware. If you could please excuse us for a second, we just want to make sure that we have the commission's decision on the last of the issues, which regards IEPR manufacturers regarding the late filing of responses to PREPA. So we just want to make sure we get that out of the docket so that then tomorrow we don't have any issues pending. Go ahead, have a seat, please identify yourself. Could you please press the button? Thank you.
John Ratnaswamy, again, one of the outside attorneys for PREPA. I just wanted to follow up for some clarification about one of the things Your Honor just said about rebuttal at the hearing.
Yeah.
Because one of the things that was said is, in general, we need to make objections today. But on the other hand, just speaking loosely, we have no idea
Exactly.
if
No,
people are
and
going to
that's-
do
and that's-
new rebuttal.
Yeah, and that's part of
Thursday or
the
something?
fluidity that I was speaking about.
So we're not-
I believe that.
We can make objections to new evidence during the hearing,
Of
can't we?
course, of
Okay.
course. Yeah. That's part of the fluidity of the hearing. However, what we're trying to ascertain today is if there was any pending objection to any documentation that, based on these orders that have been given by the commission, that the information that's been filed will be part of the record, and those that we can make a good, bring to the commissioners good information in terms of what really would be that evidence that they will see discussed by you. And then obviously the fluidity of the hearing will then bring information forth. There's information that even in a court of law being rebuttal info could potentially be admitted into the record, not only in a court of law, which is not an administrative proceeding, but at that point, then obviously it will be allowed. And then in administrative hearings, then it's more open still because the rules of evidence don't apply as strictly. So, but yeah, no, there's certainly information that we know that might be part of a question that could be objected. It could be an answer that could be objected. It could be a document that could be objected. Okay. I think I think Michael Guerra had another.
Do you want us to address other issues now
While
as
we're
long as
waiting,
we're
or-
waiting?
Yeah, if there are any other issues, we would like to clear all those out. Yeah, could you please come forward and address?
Press here? Okay, oh, it's on, okay.
Yeah, it's already.
Manuel Fernandez Mejias for Puerto Rico Manufacturers Association. Your Honor, regarding witness availability, we received an email communication from Ms. Tania Negron. That was on, the email was received on Friday, November the 18th.
Okay.
Then, unfortunately, for some technical reason, we were not able to open the attached file, which was the resolution on order regarding the instructions to inform any problems with witness availability before the 21st of November. On the 21st of November, we personally attended to the Commission's office. While filing a motion, we indicated to the Secretary that we had been having problems opening the attachment of the November 18th email, and the email was resent to us on that date, on November 21st. By the time we had access to the resolution and order, the date due date for the filing of a letter to Attorney Tania Negron, which was November 21st, had already elapsed. So we sent our email on November 22nd. Our email indicated that our witness, Mr. Mathes, he had only one date available, which was December the 15th. And of course, we have been listening to all of the positions of the parties and the Commission's position regarding this special process. We might think it might be in the best interest, instead of right away going through the severe sanction of eliminating a witness just because he's not available for one day. We have been cited, we have been asked to appear on 4 dates. He is only, Mr. Masters is only available one day. My suggestion would be that since our witness, as well as at least two or three other witnesses, do not have a report, do not have a special witness, that they be allowed to, or reschedule for one day, maybe the same December 15th, since they do not include an expert witness. They are witnesses that should have a very limited amount of data and information. And maybe the Commission could consider rescheduling all non-expert witnesses, which should be 2 or 3 of them, to December the 15th, and perhaps all of the prepas and the Commission's questions could be answered in a brief period of time, since, as you know, obviously, most of the questions and most of the time will be based on the expert witnesses. So that would be our suggestion.
All right. And is that based on your filing, like you said before, on the 21st of November? It's called moción en cumplimiento
No,
de
that's
orden?
no. I am talking about the order sent on November the 18th, stating that any problems relating to witness availability should be sent, not by motion, but by an email addressed
Exactly.
to Ms. Tania
Exactly.
Negron. The due date was November 21st.
Exactly.
I was not able to open the email attachment of that order until the evening of November 21st. So I sent my letter on November 22nd via email as instructed by the Commission's order.
Yeah.
So I am referring to that particular
Yeah.
letter.
I see, the issue that I see with your suggestion is that any of the answers given by your witness should be available for questioning by the other interveners as well as PREPA.
Yes.
So by making that, by not having stated the availability previous to the date, then other parties are again in a place of disadvantage to the information that they could have gotten from
Well, again,
the witness.
all non-expert witnesses, like ours and 2 or 3 others, the amount of information provided during the discovery and the scope of their testimony is extremely limited to special issues related to their industries or sectors. They are not expert witnesses. They have not entered in a detailed manner in the issues at this case. What I am suggesting is that instead of having them being here present 3, 4, 5 days, take 1 day for non-expert witnesses, so that they can have the opportunity to participate. All parties will be able to ask them any questions, cross-examine them on whatever, because otherwise, then, if you insist on what I consider excessive consequence of striking from the record for instance, our participation or our testimony, then that would be subject to judicial review. And that could only be and I'm being very sincere here, that could only be a problem for the commission and the procedures as a whole. What I am suggesting is a practical alternative in which non-expert witnesses that do not require hours of testimony. As a matter of fact, their testimony has already been given in their written appearance. So basically, and the discovery was extremely limited in scope to them. So in their case, PREPA and the commission or any other party could have an opportunity to ask any questions, cross-examine them, whatever, perhaps in 1 or 2 hours, instead of having them being forced to be here 3 or 4 days. In our case, my client, he has multiple business engagements, which he is not able to, would be very difficult to break, to be here on 4 different days for the whole day, just because in his testimony, a small part touched on an item that the commission considered has to be dealt in separate panels. So that would be the essence of our suggestion.
All right. Well, thank you so much. I need to speak to my Deputy General Counsel and issues regarding the commission also deciding on these and other matters.
Okay.
So we're just gonna have a small break. Yes, Mr. That's one.
An offer of sorts relating to this concern.
Go ahead. You can have a seat right here and you can turn on the microphone and
Hi, I'm John Ratnaswamy, one of the outside attorneys for PREPA. We're sensitive to the concerns that's been raised about Mr. Masses. I don't know if the commission has questions for him or other interveners do, but we're willing to waive cross-examination of Mr. Masses, if that will help. I don't know if it does or not.
yeah.
We would not want any other witnesses to be moved, as was just suggested. We've made our own plans, and
Yeah.
we have our experts here the days we thought they needed to be here. And but for Mr. Masses, we're willing to make that offer.
All right. Well, we'll take that into consideration and we'll discuss it presently with the commissioner.
And so in that case, because our problem still is a problem of time, of being here 1 day instead of 4 days.
Exactly.
So
But-
if there will be no cross examination by PREPA, and they, because, and I mean, I thank you for your position and your help on this issue. As they know, Mr. Massa's testimony is quite limited in scope, and so again, we still have to address my problem of being here 4 days or 1, and
Exactly, but you also need to address all the other parties and interveners' position, plus the position of the commission, which ultimately is the one that wants to receive the information that
course,
they
yeah.
deem that is important for their decision-making. So in that light, I think that we cannot take out of context, the need for, I mean, this orders from the commission came by, thought out well ahead of time, and with, within their discretion to provide ample opportunity for everyone to participate. Yes, Mr. Aguirre.
ICSE is not interested in asking questions from Mr. Masses.
Okay. Thank you. So we'll take a short recess for, I would say, 5-10 minutes. Thank you so much.
thank you.
Is it on if it's